No cell phones, no laptops, no tablets. That row is to be left vacant. Ladies and gentlemen, I really do appreciate your interest, but our goal and objective here is a fair and impartial trial. I don't need any additional distractions. I don't need any commentary from the gallery concerning anything that you may hear from this witness stand or from these attorneys. I want these 12 people that are going to sit in this box to receive the evidence from the witness stand. Not from any nods, not from any gestures, not from any running commentary from the gallery. This courtroom is open to the public. We most certainly will try and save seats for the immediate families of both parties, but I can't save every seat, nor do I have any intention. But we're not going to have this trial disrupted repeatedly by cell phones, laptops, and computers going off. If your cell phone or laptop goes off or I see it, I am going to confiscate it and keep it until this trial is concluded one way or another. Because I've posted the court's rules clearly, and they're not new just for this trial. I have long outlawed cell phones, laptops, and tablets. And if I see that you're being disruptive, or you're overly exaggerated, or you're nodding or giving indications to witnesses on the witness stand, I'm going to ask you to leave. Because as I said, the decisions that will be made by these 12 persons based on the evidence that they received and the law that I provided, and that alone. Okay. Mr. Gladden, are you ready to proceed with your motion in limine? With your response to the defense motion in limine concerning the data extracted from the defendant's cell phone?
Yes, Judge, I am ready. Judge, I believe before we recessed momentarily that I had gotten into some of the details of the defendant's text messages on the night of the shooting. The remainder of the proffer is that the cell phone extraction contains text messages, it contains phone calls, it contains web search history. The copy of the extraction that the state intends to admit into evidence has been redacted to omit evidence or information that has already been limited by the motions in limine. So any references to any statements that the defendant may have made to investigators in this case will be redacted. Any privileged communications between the defendant and her counsel as evidenced by the to and from names in the text messages has been redacted to avoid any violations in that regard. We have an unredacted version for the court for record purposes, but the version that the state intends to offer into evidence before the jury has removed all of that privileged information and information that has been excluded by the court's order in limine. The remaining content and context of the text messages and phone calls is relevant in this case for really two reasons, and they both go to what is required for evidence to be relevant. The case law given to the court says that first, to be relevant, the evidence has to be authentic. And then second, under the rules of evidence, to be relevant, evidence must make a fact more or less probable than it would be without the evidence, and that fact must be of consequence in determining the action. So the first question is authentication, and here I'm not talking about the authenticity of the cell phone extraction, but authentication in the sense of these are text messages that the defendant composed. And these are text messages that were sent to the defendant, and these are phone calls that the defendant made and web searches that the defendant made. And in that sense, authentication at this point is a threshold question, and what this court has to ask is whether the jury could find that the evidence is what we claim it to be. And what the Court of Criminal Appeals has said in Butler and Tienda, which I provided to the court, is that that evidence can be shown by circumstantial evidence, the nature of the conversation, the identity of the cell phone subscriber, evidence showing who was using the cell phone, information in the messages showing that it could have only come from the defendant. And so the state's proffer for that part of authentication is that the messages themselves and the data surrounding the messages will show that the defendant sent these messages and made these phone calls. Just very briefly, the text messages on September 6th start while the defendant is at DPD headquarters, and the state will have both GPS evidence and testimony from other witnesses to confirm that the defendant was at DPD headquarters. And so the text messages include statements like, "We're coming with all of them," "Why y'all have to go back," "SWAT was leaving and needed perimeter officers." This is information regarding the defendant's assignment on September 6th, and it's corroborated by the other evidence showing where the defendant was. And then there's text messages between the defendant and her partner about her partner going to a scout meeting. That's information only the defendant and her partner could know. There's text messages then showing that the defendant got to the jail at about 8 o'clock p.m. on September 6th. And again, that's where the defendant was, and there will be other evidence showing that the defendant arrived at the jail, including the GPS evidence from her car. Verizon records and the defendant's partner will also confirm that later the defendant left the Dallas Police Department Southeast station and made a telephone call with her partner just after 9:30 p.m. And there's a text message at 9:33 p.m. to the partner where the defendant says, "I'm barely walking out." And there's evidence that she plugged in her body-worn camera for that night. Again, this is just corroborating evidence that the defendant is communicating what she's doing as shown by other evidence. And then the cell phone records show that there's a 16-minute and 44-second phone call between the defendant and her partner starting at 9:38 p.m. on the 6th. Then the text messages go on to show the context surrounding the shooting. Of course, there's the 911 call, which the state will be admitting into evidence, where you can hear the defendant's voice admitting that she shot Mr. John. And the records show that call, and there is body cam video of a first responding officer that actually captures the defendant saying what we hear on the 911 call at the very end. So the evidence overlaps in showing that the defendant is the person using her phone. During the 911 call, as shown by the timestamps, the extraction shows the defendant is also sending text messages while she's on the phone with 911 to her partner. Then later she continues texting her partner using the Dallas Police Department code for a shooting, which only a police officer such as the defendant at the time would know, and telling her partner to please call her. Then later, after the shooting, there's a text where the defendant says, "They have me in a car." And this will be confirmed by dash cam video showing the defendant in a police car. The state will also have evidence from the Texas Ranger investigating this case that the investigating ranger seized the defendant's cell phone from the defendant and that she gave him the passcode to unlock the phone. The text messages go on in the days following the shooting, where she texts to her partner that there's talk of arresting her, which only she would know. She describes being scared. She describes being at the Dallas Police Association. Her partner says that he's on his way when he learns that, and he will confirm that when he testifies. And there are additional conversations between the defendant and other police officers where the defendant is asking them to go to her apartment to retrieve her belongings. She includes she verifies her apartment number at the apartment complex. Additionally, there will be body-worn camera of responding officers in the immediate aftermath of the shooting in which the defendant can be seen texting on her phone while some of these text messages are being sent. 2 days after the shooting, the defendant begins sending text messages, including to her partner, saying that she now has a new phone number and changing it. So she's confirming both her old number and her new number in those messages. And then finally, there is a text that the defendant sends to her partner 2 days after the shooting with a photo of her and the partner from an earlier time in their squad car. And she says, "I sent this so you'll know it was me." And Judge, what this proffer is meant to do is to show there is mountains of circumstantial evidence that this court can consider to find that the jury could conclude that the text messages on the phone were written by the defendant or sent to the defendant, and that the phone calls were made by the defendant or to the defendant, and that the web searches were made by the defendant. There is plenty of evidence to satisfy the Butler and Tienda standard for authentication under 901 to that respect, and that is the first step of the relevance analysis, because obviously if the defendant doesn't send all of these messages, then how can they go to what I'm about to say, which is her state of mind during the shooting, both before, during, and after the shooting. The relevant facts in this case are the defendant's state of mind coming to the shooting, her state of mind when she shot Mr. John, and her state of mind after shooting Mr. John. The reason why all three are relevant is because her state of mind at the time of the shooting goes directly to her intent, which is an element of the offense. But the state expects the evidence to show, just from the 911 call, that the defendant will say, "I shot a man." So the evidence will show that the defendant intentionally killed an individual. So the elements of the offense are met there. What this case is going to be about, as you heard from Mr. Rogers earlier, is the question of justification. And justification goes to whether a defendant had a reasonable belief that her use of deadly force was immediately necessary. And the reasonableness of that belief is based on an ordinary and prudent person acting in the same circumstances as the defendant. So what we have to establish is the same circumstances the defendant was in and how an ordinary and prudent person would have behaved. So what the contents of the cell phone extraction show, first of all, is what the defendant was actually doing during the course of the day. This goes to just how much work she had done. It gets into the question of her fatigue, not talking in this case about the expert issue we discussed earlier, but simply whether or not she was tired, how much work she had done, who she had been talking to, what she had been doing during the day. Additionally, the content of the messages show that the defendant at least had enough attention going to her apartment that she was able to safely drive. She was able to get through a narrow parking garage. She was able to drive her vehicle to her apartment without getting lost while talking on a phone. The messages are going to show that, or the extraction is going to show that the defendant was on her phone with her partner while she was driving back to her parking garage. And so that's going to show the lack of fatigue that she actually exhibited. She was able to get home safely. But then the content of the text messages is going to show that at some point her mindset changed. And that mindset changed in a way that the defendant began to stop paying attention to what was around her in an unreasonable manner. And to show that it was an unreasonable manner, the state proffers that there has to be more than simply showing she had been sending text messages back and forth. Sending a text message doesn't divert your attention. But thinking about the content of those messages and thinking about the content of the phone call can divert your attention. And then it's a question of whether that makes her diversion of attention reasonable or unreasonable. What do I mean by diversion of attention? That she failed to notice all of the clues as to where she was at. And part of the defensive theory of justification is going to be for her to believe whether deadly force was immediately necessary is, was she reasonable in knowing where she was at? Now that's not going to be in the jury charge, but that's certainly a fact that we are all going to be arguing in this trial, is what was the reasonableness of every decision that she made leading up to the shooting. And then of course, during the shooting, or during the 911 call, we have the additional text information to her partner. And that text is going to continue to show that. Do you want me to end the content of that text? Yeah. In the text to her partner, she says, "I fucked up." And so that's going to go directly to her consciousness of guilt, which a person's statements and actions before and after a shooting is relevant evidence to their culpable mental state and their consciousness of guilt. So, Judge, as the phone conversation I mentioned earlier that the defendant was on while driving home, the timing, an additional relevant aspect of the cell phone extraction for that is the timing. That phone call ended just over 3 minutes before the state believes Mr. John was shot. And so the way in which the substance of that conversation, as can be inferred from the text messages and the testimony from the defendant's partner and other officers, the substance of that message goes directly to the defendant's state of mind at the time she's walking to Mr. Jones' apartment, the time she goes in and shoots him. So that is in a nutshell the state's argument for the relevance of this information, Judge. Responding to that first part of the motion in limine.
Does you wish to reply, or will you continue with your further objections? Mr. Muller, did you wish to?
I was going to wait to see Mr. Gladden proffers that under all the theories that he wants to propound to the court, and I'll respond.
Okay. And so, Judge, the defense's second objection following the relevance objection is their 403 objection. And this court is well aware, I know, of Rule 403, that relevant evidence can be excluded if its probative value is substantially outweighed by a danger of unfair prejudice, confusing the issues, misleading the jury, undue delay, or needlessly presenting cumulative evidence. Case law is clear that Rule 403, despite its use of the word exclude, is a rule that favors admissibility. And that's Davis v. State, 329 Southwest 3rd, 806, Hammer v. State, 296 Southwest 3rd at 568 to 69. I didn't provide the court copies of those cases. They're not directly on point factually. It's just for the record to show the statement of law that Rule 403 embodies a presumption that relevant evidence is going to be more probative than it is prejudicial. And the burden is on the defense to show a clear disparity between any prejudicial effect and any probative value. All the evidence that we offer is going to be prejudicial to the defendant. That's why we offer it. The question is whether that prejudice substantially outweighs the probative value. Well, the probative value here is the defendant's mental state and the reasonableness of any belief that she claims to have during the shooting. That's incredibly relevant because one is an element of the offense and one is the essential disputed element of the issue of justification in this case. Now, the defense presents our theory of prejudicial effect as we just want to cast the defendant in a bad light and say that a person who would send these types of messages, have these conversations, have these types of relationships is a bad person, and of course she's going to shoot somebody. That's not our argument at all. Our argument is the reasonableness of her mindset and her mental state at the time of the shooting. That's the relevance of the evidence, not to cast her in a bad light. The next objection in the motion eliminated by my count is the Confrontation Clause objection.